Ladies and gentlemen, and welcome to the Senate Committee on Public Safety. We're going to call this meeting to order. I'm going to ask our very own Senator Payne if he wouldn't mind opening us in a word of prayer.
Number 3. Let us pray. Dear Heavenly Father, we come to you today, Lord, and we just thank you for all of our many blessings first and foremost, Lord. Thank you for all the many things that you bless us each and every day with, for the breath of life, and that we can serve you, Father. Lord, we just ask you to guide us in all the things that we do in this proceedings. Give us clear eyes and mind of discernment that your will be done in all things. For us in Jesus' name we pray. Amen.
Amen. Thank you. Before we get on to our bills we'll be hearing today, we're going to assign 2 bills to subcommittee. One first that's chaired by Senator Robertson will get Senate Bill 175. We'll make sure we'll get that over to you. And then the General Welfare Subcommittee, which is chaired by Senator Payne, will be getting Senate Bill 71. But we'll get that information over to you as well. Today we're going to hear 4 bills. We're going to begin with Senator Emanuel Jones. If you wouldn't mind coming to the podium so the millions viewing online can see you, sir. Would you mind going to the podium? Yep, thank you. And first I want to thank you personally and publicly for working with Judge Jackson, who I know is going to come up as well and talk about some things that we believed were complementary on these 2 bills. And I know you've been very passionate about this issue and passed legislation last year. So we will turn it over to you for Senate Bill 10.
Thank you, Mr. Chairman and members of this committee. I call Senate Bill 10 Drag Racing 2.0. This legislation makes some minor changes from what was passed 2 years ago. And the bill 2 years ago passed unanimously out of the House. The changes that are in this bill are designed to address some of those issues with those groups out there that are laying tracks and doing drag, and those groups that are out there that are organized in their efforts regarding stunt driving and speed racing and reckless driving. The key changes to the bill is that it provides for the authority of issues of bond and uniform traffic citations for a court authorized to hear traffic cases. That's one of the key changes from last year. Of course, and Mr. Chairman, if you would like, I'll be more than willing to step right through the original bill as well as the substitute. Over on page 2 of the original bill, starting at line 19, this bill, any person who is knowingly present and actively facilitating an exhibition of illegal drag races is a violation. So this section in here is just to target those that are present, that are organized, that are creating havoc and blocking roads and streets in our neighborhoods and on our interstates and highways. Over on page 3 of this bill, I'm looking at LC 393569. And I will address the substitute later, which is LC 393769S. Another change, again, is this bill is designed to address the reckless stunt driving in violation of this code section. Another change that was made was over on page 4, where the fines were increased as well.
Senator, I just want to stop you for 1 second. I think we're operating from the substitute of LC 393790S.
3937? I'll use that.
393790S, yes.
Yes, I use that substitute
Okay.
because the pages did renumber
Gotcha.
a little bit better.
All right, thank you.
And over on page 4 of the substitute, 393769S, that same language to see where the fines were increased. And over on page 5 of the substitute, there was some language that was stricken. And in its place, over on line 101 and 102, it addresses the previous convicted of a violation of this code section. The substantive changes for the substitute is over on page 6. And they start on line number 124. And I know there would be more to say about these particular changes that were made over on page 6.
Very good.
Chairman, that's pretty much it for Senate Bill 10.
Thank you, Senator, and appreciate your good work in this. We will wait to talk about the Section 4, because I'm going to ask Judge Jackson to talk about that. But while we have the bill's author up here, are there any questions about the first 3 sections of the bill for Senator Jones? I had a question from Senator Dugan.
Council number 4, Mr. Chairman. And I know it sounds bad, I just don't know what it means. Reckless stunt driving. Can you give me an example of what stunt driving is and how
Thank
it
you.
could be non-reckless?
Thank you, Mr. Chairman. That's an excellent question, by the way. When there's harm to property or people, then it really becomes reckless. And that's the definition that we're using in this language.
Okay. All right.
If I could answer that question a little more, I think that what you're thinking of is maybe people who are drifting and things of that nature, and putting cars in a place that tend to cause a lot of harm, and if they get away from that drift, especially when there are large crowds gathering, there's been unfortunate instances from that as well.
Okay. Thank you.
Question from Senator Robertson.
First of all, Senator Jones, this is good legislation, and hopefully I believe it's going to make our streets safer and save some lives.
Thank you, Mr. Chairman.
I just want to point out on line 25, where it says less than 250, and then if you look on line 70, 75, 80, and 85, it talks about the amounts of the fines. Would those be mandatory minimums?
You certainly could use that term, but again, the purpose of this legislation is to increase the penalty and deter, to act as a deterrent from those out there that are committing these offenses.
Absolutely. Thank you.
You're welcome.
Other questions for Senator Jones? Okay, we're going to ask you if you could just take a seat, because we might need to call you back up, and I'm going to ask Judge
Mr.
Jackson, who was very kind to come to our last meeting, and we found that we thought that his issue definitely needed to be in legislation, but we thought this bill would be a better fit. So I think you described to us, Your Honor, the problem. What I really want to do today is just talk about the language change and what that is going to mean beginning in Section 4, please.
Thank you, Mr. Chairman. My name is Gary Jackson. I'm a judge in the Atlanta Municipal Court. I've been on the bench 34 years, 23 full-time. I'm here today as an individual, not as a representative of my court and not as representative of my counsel. Here's the problem that we're facing, particularly in Atlanta and in other counties. A driver comes in front of me at 140 miles an hour. Because traffic cases in Georgia are criminal, that driver has a right, a constitutional right to a jury trial. The defendant asks for a jury trial. We bind the case over to state court, usually Fulton State. Because the old traffic court that used to exist in 2014 has been abolished, it has to go to state court. We can't hold a jury trial. We don't have the legal authority to do it as a municipal court. No municipal court can do that. We send the case over because of the backlog in Fulton State Court. That defendant will not see a trial for between 18 and 24 months. That driver is completely unsupervised in any way and can wreak havoc during that lengthy period of time. And they are doing that. We have frequent flyers, repeat offenders like you wouldn't believe. I've seen people back in at 90 miles an hour. Didn't I just bind you over last month at 100? They did. Our court's been open since October of 2020. In those 28 months, I've seen more 90 and 100 mile an hour speeders than I've seen in 28 years. There is an epidemic of maniacal driving, not only throughout the state, but particularly in Atlanta. And there are some municipal courts where the county does not have a state court. For example, if you're in Pine Mountain, Georgia, in Harris County, where my family used to live, they don't have a state court. You get bound over to Superior Court, and they only come up to Hamilton twice a year. So you're going to have another long period of time with an unsupervised driver. Some of these drivers I've seen have had 29 tickets, 8 or more super speeders, each ticket faster than the next. There has to be a solution. The problem is the bind-over statute, which is 40-1323, says when a defendant asks for a jury trial, it must immediately be bound over. And there's a question as to whether a judge can put any restriction on that driver, because the defense counsel say that you've lost jurisdiction, you can't do anything. So I'll take my jury trial, walk out the door. The way to solve that problem is let the committing judge, the trial judge who has to bind the case over, say, wait a minute, let's stop. Let's look at your record. Is your driving so bad and so dangerous that you present a serious danger to public safety? And if you do, let the judge say, okay, we're going to either restrict your driving to work, school, church, or the doctor, or we're going to suspend you completely. We are literally going to kick you out of your car until this case is over. And you might say, well, gee, that's an awfully harsh thing to do. Well, in domestic violence cases, we eject people from their homes, unfortunately, fairly regularly, to protect the family from danger. If we can keep somebody out of their house to protect the family from danger, why can't we keep them out of their car to protect the motoring public from danger? It's really the same thing. We as judges took the same oath, Mr. Chairman, that you and your fellow senators did. We took an oath to protect public safety. Article 1, Section 1, Paragraph 2 of our state constitution says it is the duty of government to protect public safety and property. And in lines 125 to 130, that would give a judge like me the power to say, wait a minute, we're going to send your case to a jury, but let's take a look at protecting public safety. And some people get arrested and get an actual bond. Most people in Atlanta, they don't even arrest them. They just give them a ticket. And that's a uniform traffic citation. Some people don't think that's a bond, and that issue hadn't been decided. So that's why you see that language on line 126. Mr. Chairman, I would request one small change on line 130, where it says you can suspend a driver's license. Why not also put or restrict a driver's license? You don't need to completely suspend somebody in every case because every record is different, every driver is different. Maybe just a restriction like we do with the DUI limited permits. Maybe that's enough to get the messages across. Hey, you driver, you need to slow down. You're not only endangering yourself, but you're endangering me and you and everybody in the public. So I humbly request, and if I could get down on one knee, and I have an artificial knee so I couldn't get up, I would beg you to pass this substitute and just add the words or to the restriction or suspension in line 130. But this bill will save lives. And individually, I echo the sponsor of this bill. We've seen donut driving, every kind of stunt driving. Every time you think you've seen it all, there's another post on the internet where these people are just acting crazy, and they have to be reined in. They are doing dangerous things, and some of these people, quite frankly, are dangerous people. They don't need to be behind the wheel of an automobile.
Thank you, Your Honor. I agree, and I want to clarify for the committee's understanding. We're not talking about someone who one time, got clocked for doing 67 and a 55 going down the connector. We're talking about repeat super speeder type events on and on who are a danger. And thank you, Your Honor, for bringing this forward. You and I have talked about this a few times over the years, and I appreciate your passion and tenacity because it is a true public safety issue. And similar to Senator Emanuel Jones, one of the things I think is really important about this bill is it's the crowds that are gathering and encouraging and doing that stuff, right? If you are there to help make all that happen, you are a party of that crime, right? And we can dissipate, and there's not crowds and there's penalties. It is proven in the past it does make these things certainly tamp down to a much lesser level than they are today. So kudos to you. Are there questions for Judge Jackson for Section 4? I have a question from Senator Kim Jackson. Does Jackson?
Very well
connection?
named, I might
yes,
say.
Yeah.
It is. Thank you, Mr. Chairman. Actually, my question may be for both the judge and for you, Mr. Chairman. Mr. Chairman, you said that this would only apply to people who were super speeders, who had been habitual, problems in this case. But I don't see, and perhaps, Judge, you can point this out to me, I don't see anywhere where it actually describes that as a condition for this.
It does not go into exact detail there, but we trust our judges. Their goal is not to bring harm against the individual from their court, it's to protect the public. We could certainly put into the law every T&C for everything that happened, but boy, we'd have a OCGA that would be 50 feet high once we printed it out. So,
Mr. Chairman, when you get a record, when you pull the DDS record, and I pull every record on anything 90 or higher, and it's running 5, 6, and 7 pages, Raise your hand if you've driven to the General Assembly at 70, 75 miles an hour on the interstate and been blown off the road lately. We all can raise our hands. And I don't like ever having to take someone's license. I said, I don't take your license, you gave it up. And our goal, at least in our court, we want safe drivers in safe insured vehicles that are trying to obey the road. We all make mistakes. That's why we have no contest pleas. But when you get these people with 29 tickets, 12 suspensions, habitual violator revocations, and they're still speeding, and each speed seems to be faster, that's when you sit back and say, my goodness, they want a jury trial. They're going to sit here for 18 to 24 months in Fulton, at least 6 to 12 months in Harris County, and I litigated down there, and nobody's looking over these folks. There's nobody to supervise them, and the frequent flyers know this. It's not their first trip to the rodeo. They've been in court a half a dozen or a dozen times. They know the drill. Ask for a jury trial, and on the way you go.
Yeah, thank you, Your
May I
Honor.
follow
One
up?
more question from Senator Jackson.
Well, just as a follow-up, so in the sections that are before this, Senator Jones has delineated out the first offense, there's this kind of charge, the second offense, this happens, the third offense. So we do go into that kind of detail as it relates to these types of experiences. And so I'm curious, I mean, Judge, what I'm hearing from you is that you want to be able to do this for repeat offenders, for your frequent flyers. But what you have here does not actually specify that.
Well, occasionally you will get someone who's well into triple figures with nothing on their record. This happens. Usually the first question that I ask is, what's going on in your life? You have a divorce, an illness, a death. But I had a lady, only her third ticket, 72 in a 25 school zone. It was her third super speeder school zone. Within 2 years, her excuse was, I'm taking my child to school and I was late. Now, in that case, she pled out. Had she asked for a jury trial, even only with 3 offenses on her record, she would have been unsupervised for 2 years. So, as the chairman indicates, to a certain extent, you have to trust us that we can see the real bad ones. Nobody's out, and these hearings take a long time. And today was a light day. I had 133 cases. Judges will work as long as it takes. But you're not going to see these very often. Only, unfortunately, I'm seeing them more and more. And yes, Senator, to a certain extent, you're going to have to trust us to exercise the judgment that we have. And if we're not exercising good judgment, either, like me, they'll vote me out of office, or the JQC will be on top of me for being over the top. But you are correct on a specific offense, second and third. But something like this, for example, somebody may be charged with aggravated assault. It may be their first offense. It may be their fourth. There are no specific guidelines on a judge setting bond in that case. And the 2 questions are, A, will the defendant show up to court? And B, while they're out on bond, will they continue to violate the law? If somebody's got one offense, well, they're not going to continue to violate the law. Bind it over. You don't need to worry about that driver. They're scared enough already having to face a jury. And we make these decisions in bonding cases all the time, by the hundreds every day. And every defendant is different, and every case is different. So we want to have that discretion, and yes, you'll have to trust us to a certain extent.
Okay.
But I don't like putting people in jail. That means either I or some of my brothers and sisters on the bench failed. We couldn't get the message through. But after 29 cases, you almost say to a defendant, I'm not any better than the other 28 judges that you've had, but I'm maybe the one you remember. But at some point, you have to say something's got to be done.
Thank you, Your Honor. I'm going to ask Jenna, could you come up to one of the microphones? So we're going to ask you a question here to clarify something. I just want to make sure that we have a right amendment language on line 130, because I don't think there's a restricted license. I think there's a limited driving permit in the code. Is that not correct?
That would be even better language.
Yeah, okay.
You'd probably want to also add them to the list. I think that's where it becomes problematic. There's a specific list
Okay.
in other parts of the code. I don't see DDS here, but
No, but they are sending me text messages in real time, so.
You are
Okay.
correct. You are correct, Mr. Chairman and
Okay.
counsel. There is a list of limited permits, and you generally see it in the DUI setting, work, school, church, and doctor, something like that.
Okay, so if we were to say something along the lines of after suspension, or limiting driving permit as agreed to by the judge or something of that nature? Help me out here.
Okay, so
40-5
suspension of
dash,
a
oh, I
driver's
can't
license
remember.
or issuance of a limited driving permit.
Will that cover it?
I think
Okay,
so.
or issuance of a limited drive, okay. All right. We're getting texted in real time.
Senator, I don't mean to refer to Harris County, but that's near and dear to my heart.
Okay, all right, they just said limited driving permit, okay.
It
Okay,
is.
all right, so we've got several more bills here, and we're gonna knock everybody out at a time, so I thought Senator Robertson said he wanted to make an amendment, is that true? Yeah.
Mr. Chair, I make the motion that we amend the bill using the language crafted by alleged counsel.
Okay, that said, after the word suspension on line 30,
Correct.
the words "or limited driving permit," comma, of a driver's license, is that correct? Okay.
Yeah.
All right. Can you say that out loud?
Line 130, between after license or issuance of a limited driving permit.
Okay. Yeah. License or issue of a limited driving permit. Okay. So I've got a motion from Senator Robertson to make for the amendment. Is there a second? Second from Senator Dugan. Any further discussion on the amendment? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. The bill is now amended. Any other discussion from the committee members? We have one more person signed up. Miss Maisie Lynn and Dan, you come on down, but you're going to have to be quick because we got a lot of bills.
I understand. Thank you, Chairman. I appreciate you hearing from us. We have not had the privilege of actually seeing the sub, so I can't speak very specifically to it. I did reach out to Senator Jones this morning. We spoke at the ropes. He did not have a copy at that time that he could share with me. I reached out to your office as well because I understood there was a sub. I was not provided one. I really would love to speak to it because we do have laws on our books right now that address habitual violators in Georgia. We have point systems in our moving violation code that address suspending licenses in Georgia, but I can't bring you the specifics because I don't know what's in your bill. But I believe that a lot of what Judge Jackson has described is covered already, that suspensions are available to judges, and I am concerned that this is unconstitutional for several reasons. One, it's pretrial punishment. The people that Judge Jackson is describing are people who have been accused of, for instance, speeding several times, and they are pretrial. And yes, our court systems, even without a backlog, our court systems are set up so that there is time for the prosecution to do their job. There's a 2-year statute of limitations on misdemeanors. So we know that it's going to take up to 2 years to get that case going in state court. And to further penalize people who are simply accused in our state, it is a pretrial penalty. And in addition to that, you're doing it because they've invoked their right to a jury trial, which is a Sixth Amendment guarantee of a guarantee under the Sixth Amendment of our Constitution. So I'm just going to raise for you now that I do have concerns that what you're passing, it sounds like to me, is unconstitutional. I'd be happy to take a look at it and send you all a memo with our feedback if there's time to do that.
We'd
Although I realize you wanna
always
vote
like
on
to
the
hear
bill
your
today.
feedback, Maisie. I think Senator Robertson wants to add some context.
Maisie, real quick, I haven't made a DUI case in quite a while. When an individual stopped for a DUI and they either refuse the Alka-Seltzer, or excuse me, the intoximeter, not the Alka-Seltzer, but the intoximeter, and when they leave the jail, are they not given a temporary driving permit still, and then they'll be notified to report to DDS for a implied consent hearing?
I want to introduce you now to Dan DeWaskin, who
Okay.
is a practicing attorney. I've been out of the courtroom for a minute too, so
Okay.
I'll let him take
So,
this one.
to address your question, they're given a 1205 and ALS, if they are, and sometimes they may not get a copy. and
My question is, are they? In many cases, are they?
in many cases, they are.
Is that pretrial?
It is pretrial.
Okay, thank you. That was my only question. I just want to clarify that
Okay.
to make sure that my mind was right.
But if I can just expand upon that for 10 seconds.
Sure.
There are several due process and procedural provisions for that, meaning that in that law, it goes very, very far into administrative law in that when you appeal that, you pay a $150 fee to appeal it. It goes to DDS through Conyers. They set a separate hearing.
I understand that, but if they're stopped 3 days later prior to any appeal hearing and an officer asks for a driver's license, they hand them that citation with the sticker on the bottom, correct?
Correct.
It
Or-
acts as their restricted driving permit, correct? Okay, thank you.
Thank you, Macy.
Sure.
Macy, we're going to have to finish up in 5 seconds.
Can we
so-
talk to the substance of the bill? So the underlying bill, or is that still available?
Very, very quickly,
Yeah.
please.
So, as you heard, this, the language that makes up the code sections that are addressed in Senate Bill 10 were passed in 2021. Governor's Bill, HB 534, went into effect in May of 2021. So here we are. It's a similar conversations that I've had at this podium before about having laws on the books that have not yet been applied in a meaningful way to know what kind of impact they have. I will happily, I haven't done this, but I will send you all some information about how we know from studies that enhancing penalties is not a way to deter crime. We don't even know if the governor's penalties are deterring these crimes, because these crimes have not been, these crimes that we're addressing today have not yet gotten through the court system. And here we are raising these punishments higher than what is on the books now for DUIs in these moving violation cases. We're talking about a mandatory minimum 1 year in prison, or in this case, probably jail, which is on a fourth or subsequent, but on a fourth or subsequent DUI, that's not where you are. So just want to bring some relevant equity to our laws. If that's really what you want to do as a policy matter, obviously that is a policy decision to make, but I would just want to raise the point so that you're making it with open eyes.
Thank you. Appreciate your testimony today. Your Honor, 5 seconds or less, please.
Strickland v. State, a 2009 Georgia Appeals decision, volume 300, I don't recall the page, already ruled that bond is not punishment, it's not double jeopardy, it is not unconstitutional. That issue was ruled upon 14 years ago when a defendant was on her fourth DUI and the judge restricted or suspended the license. It went up on appeal, those exact issues. The trial judge's decision was upheld, and Judge Carley indicated that we're going to uphold a bonding decision by a trial judge who's there on the case, absent abuse of discretion. Those arguments have been made and lost
Thank you,
14
Your Honor.
years ago.
Thank you. Okay. I appreciate all the feedback. We did pass the amendment. We now have a perfected committee substitute. So is there a motion on the committee substitute from Senator Robertson?
Yes, Mr. Chair, motion do pass.
A motion to
Senate
pass?
substitute.
Second from Senator Payne. Further discussion of the committee members? Seeing none, all those in favor, please raise your hand. 1, 2, 3, 4, 5. What? What? Are we up or down, Senator Jackson? Okay. All right. And all opposed, like sign. Okay, one nay. Congratulations, Senator Jones. Best of wishes in the Rules Committee. All right. To the very patient Senator and Chairwoman Kirkpatrick, would you please come to the podium so all your fans at home can see your smiling face? And while she's coming up, if I could have Robert Smith, if you forgot to fill out part of the form here, so I'm going to pass that around. If you could finish filling it in. We got to take copious notes here. And while you're a regular, we need to fill in the blanks. Okay. Senator Kirkpatrick, please talk to us about Senate Bill 155.
Thank you, Mr. Chairman. I'm working from LC 393776S. Is that what you got?
Yep.
Okay. This has to do with public safety animals. Georgia has a long history of protecting public safety animals dating back to 1983. This section of the law was amended in 2015 with the passage of Tanya's Law, arising out of the death of Canine Tanya in Walker County, shot and killed in the line of duty. While the intent of the bill was good, it created several unintended legal consequences, including conflict between the categories that were created. This bill simplifies the categories so that there will be 3 instead of 4, which eliminates the ambiguity between the various degrees. It also simplifies the definition of public safety animals so that it matches with federal law, and it requires restitution to the owner of the animal for the cost of veterinary expenses and retraining to allow the animal to resume its duties. And I have been working with the Prosecuting Attorneys Council and also Prosecutor Kim Schwartz from Columbus on the bill. And as you know, my law degree came from the Judiciary Committee, and so it is possible that if we get into the weeds too much on a legal question, I may have to reach out to one of my friends. But if you'd like, I can briefly walk through the sections.
Please do.
Okay. Section 2 really simplifies the definition of a public safety animal and eliminates a whole lot of categories. This has been updated in many other states and in federal law. The next part talks about what happens in the 3 different categories. And the categories, you can see it in your bill summary, are based on the first one, and the mildest is interfering with a public safety animal. That would be harassment or something like that, and that's a misdemeanor. The second category is harming a public safety animal or search and rescue animal, and that is a misdemeanor of a high and aggravated nature, and the penalties are in the summary that you have. And then the third category is aggravated harming, and that could result in the permanent disability or death of the animal, and that is a felony. And that also matches federal law. The last section of the bill talks about restitution, about paying for vet bills, and also retraining to get the animal back out with acting as a canine officer. And then the very last part eliminates the requirement for the GBI to do forensic examination on the law enforcement animal. That is handled in a different way. So I'll be happy to try to answer any questions. I probably should tell you that the conflict that I was referring to between the different degrees of harm was, it hinged around one of the degrees was use of a deadly weapon, and then the other degree was use of a firearm, and a firearm is a deadly weapon. So this just cleans up the bill, and I'd be happy to answer any questions.
Well, Senator, first, thank you for bringing this forward. I think it's an excellent piece of legislation. Isn't it true that all areas of law enforcement spend considerable amounts of the taxpayers' dollars, time, and effort in order to train, in most cases, a canine officer? Is that not true?
It is, and we have growing uses for these animals, and which is another reason to simplify the definition. They're being used for everything from the traditional uses to sniffing out electronic things in child pornography, for example, and other things that will be coming down the road that we don't even know what they're going to be. So that's why it's better to have a broader, more general definition than the specifics.
And isn't it true, all of us that have or currently work in public safety, consider those whether it be a dog or any other animal, as a part of that team, right? That is out there actively protecting the public, and in some cases putting their lives on the line in order to protect everyone. Is that not true?
That's absolutely true. They're put at the same risk as our human officers.
Thank you. Okay, questions for the bill's author. I've got one from Senator Dugan.
Thank you, Mr. Chairman. Line 60, and I think it's a great bill. I support what you're doing here. But there, oftentimes in these things, I see words that just jump out at me, and I don't understand what you mean. How do you tease a support animal? I mean, you call it names, or what are you doing? Because if you're doing something physically, that would be agitate or harass.
Well, I think what we saw back in 2020 during the time of the civil unrest that we had downtown were rioters deliberately spooking police horses, harassing the police dogs, trying to release them from their containment, that type of thing.
Okay.
Senator Dugan, are you having an issue with the word tease? Is that
I am.
That is one that I kind of circled as well. So, okay. All right. Well, we may come back to that one. Other
I
questions?
think if you wanted to take the word teases out, I wouldn't object to that.
It just seems really, really general to me, and the others are very specific in what they do.
Okay. All right. Other questions for Senator Kirkpatrick? All right. We've got a couple people signed up to speak. If you wouldn't mind staying close, Senator. First, now fully filled out, Mr. Robert Smith with the Prosecuting Attorney's Council.
Good afternoon, and I want to apologize first. Jessica Rock, our animal crimes prosecutor, I couldn't get her here 2 days in a row. Yesterday, she was doing a search warrant up in North Georgia, and I managed to drag her away from that. Today, she had a prior engagement, and she wanted to apologize for not being here.
Tell her I'm questioning her loyalty the next time you see her.
I understand. Unfortunately, we only have one, and when you only have one animal crimes prosecutor in the state, and we have 159 counties, she's got to be everywhere at all times. To answer your question about teas, Senator Dugan, if you have a treat or some sort of item and you keep holding it and getting the animal to react to it and keep pulling it away, that is an indicator. That is one way you could possibly tease an animal. So I'm not sure if that's something you want to think about and why to keep it in. This means something a little bit different.
Would that not agitate them?
It could. It depends on how you want to characterize it. Agitating, in my mind, if I agitate someone, or if someone's agitating a public safety animal, or it would be more towards getting the animal angry. Whereas the teasing is holding the treat and not providing it to them. That it's a matter of semantics.
Yeah, Senator Robertson did some quick legal Googling, and maybe replacing tease with taunt would make a little bit more sense.
A taunt I buy.
Okay. All right.
But I do want to. But overall, this bill is a good policy. There's some changes that needed to be made, especially when it comes to the GBI. Removing that because the GBI has never done this. They've never had the training. They've never had the facilities to do these necropsies. So removing that from code is good policy. The tightening up the definitions, being more specific rather than giving lists, is always preferable. I'm not going to speak to the policy decision about what the appropriate punishments are, as our usual stance on those. And I want to thank Senator Kirkpatrick for giving us the opportunity to be part of this discussion. I'm here primarily to answer any questions you may have, from a prosecutor's perspective about what this bill does or doesn't do. This is a tool. This is something that we could use. This is something that does make some changes that need to be made to this code.
Thank you very much, Robert. Questions? Seeing none, thank you so much.
Thank you for your time.
Next, we have Kimberly Schwartz from the District Attorney's Office of the Chattahoochee Circuit.
Good afternoon, Chairman Albers and other distinguished senators on this committee. It's an honor to come before you both as a 36-year prosecutor and the proud wife of a canine handler for 20 years or so, and to urge a due pass on this particular bill. The major goal here is to put Georgia's public safety animals on an even footing as far as deterrence and protection with their federal counterparts. If a bad guy who is being chased, and again, usually we're talking about a police dog here, being chased by a public safety animal, and the bad guy turns around and shoots at that animal and hits it, if the guy at the other end of the leash is a federal marshal, he's looking at a 10-year felony. If the guy at the other end of the leash is a state trooper, he's only looking at a 5-year felony. And if he shoots at the dog and doesn't hit it, and the guy at the other end of the leash is a U.S. Marshal, he's still looking at a 10-year felony because, again, we want to deter the behavior that is likely to cause harm and not require that it actually does cause harm. And we trust our judges then to differentiate within that sentencing range, and our prosecutors and our defense attorneys to come to good recommendations about what justice looks like within that range. But if it's a shoot and a miss, that defendant, if it's a Georgia animal, Georgia State Patrol animal, or Harris County Sheriff's Office animal, defendant gets a 75% discount on his sentence. He is looking at only 2.5 years. And there's a lot of us out here that just feel like Georgia can do better on this, and that these animals and, frankly, the taxpayers who put the bill for them deserve better and need more protection than our law currently provides. We concur with the Prosecuting Attorney's Council about the removal of the GBI provision. I think that was, folks meant well on that, but it was not workable, and that it probably needs to come out. We are very much in favor of the mandatory restitution provisions, including all aspects of veterinary care, replacement, and restorative training if that needs to take place, if it's an animal that can go back into service.
Kimberly, just for timing's sake, don't talk us out of it.
Yes, sir. All right.
All right.
Thank you.
Thank you. I appreciate it. Maisie and Dan, come on down. Thank you.
Thank you again, Chairman. I wouldn't be doing my job if I didn't raise issue with the mandatory minimum provision of this bill, which does not line up with federal law, actually. The federal law is a maximum of 10 years. It does not require the 2 years that this bill requires, and we would simply ask you to, although if the floor is going to be 2 years, remove the mandatory minimum provisions. And I don't have the correct line numbers because I don't have this sub either, but it's somewhere in the vicinity of 92 to 94 where that mandatory minimum language showed up in the original bill. And the federal law I'm citing to get that 1 to 10 is 18 U.S.C. 1368, just to be sure we're all on the same page about which law we're trying to align with, I guess.
And Maisie, just for everybody's edification, it's on line 93, and it was changed from imprisonment of not less than 1 to not less than 2. And then no more than 5 gets struck into 10, just to make sure you understand where that was. So.
Right, but then at least in the original where it continues on, it says a fine not to exceed $50,000 or both, and the first 2 years of such sentence shall not be suspended, probated, deferred, or withheld by a sentencing court. So that's the language that I'm referring to.
Sure.
And when I did speak with Senator Kirkpatrick this morning, she did mention that that the design was to bring things into alignment. So I understand if you all don't want to, but I think that would do that for you.
Thank you.
Along with Senator Dugan, who may be, I'm not as, the idea of taunts doesn't mitigate my concern about teases. I do believe harasses is a broad word that probably gets you exactly what you need, along with tampers. The other 2 words I'm concerned about are frightens and agitates. That seems to me like anthropomorphism, and I'm not sure how we would get to that. And we're basically taking some subjective human's belief about what a dog is feeling in order to prosecute someone for their behavior, when I think you can penalize the behavior, but these are animals, and they're trained to act in certain ways, potentially not like my dog would at home if someone came at him, in an aggressive way. I mean, I've certainly been around animals that respond in ways that I think means they're frightened, but that is definitely
Thank you, Maisie.
potentially outside the ken of a fact finder in these
And I
cases.
believe what Senator Kirkpatrick was referencing, though, is people were lighting fireworks literally right underneath a horse, which absolutely frightened, spooked, and scared them. Through some cases, their riders off and harmed people. But thank you. I appreciate that.
Also, that is also harassing and tampering with the animal. I think it's covered is all I'm suggesting without getting into those subjective and vague terms.
Okay, thank you. All right. I think we're going to get back to the bill on page 3, line 60. I think there might be an adjustment from Senator Dugan for that one. Is there something you might want to change there, Senator, on line 60? Yes.
Mr. Chairman, I am really a fan of the word taunt.
That's a good word.
If we could change tease to taunt, I think we're
Are you okay with that? Okay. All right. So what I hear is you're making an amendment on line 63 to strike the word teases with the word taunts.
I have it on 60.
On 60, I'm sorry.
Yeah.
I'm sorry, 60. You're going to replace teases, strike that with taunts.
Yes, Mr. Chairman. Thank you.
Okay. That was a great amendment. Who's got a second on that amendment? Senator Roberts. Any further discussion on the amendment? Seeing none, all those in favor, please say aye.
Aye.
All opposed, please say no. We now have a perfected committee substitute. I've got a question.
Mr. Chairman, I'd like to have a question to the author, if it's appropriate.
Come on back down, if you wouldn't mind, Senator Kirkpatrick.
Senator Kirkpatrick, we heard in testimony that your goal here is to try to align the state laws with the federal laws as it relates to how we treat these types of situations. And so I'm wondering if you would be amenable to us aligning it truly by removing the mandatory minimum language that's found on lines 94 through 96. So it would remove, it would allow for the sentence to be probated if the judge, whom we're trusting, because we've talked a lot about how we're going to trust judges, if they saw necessary that they could give something less than 2 years. That would bring us into federal compliance. I'm just asking if you'd be willing.
Mr. Chairman, do you mind if I speak with the prosecuting attorney's counsel briefly or ask them to comment on that?
Why don't you go take a 30-second aside
Okay.
while we discuss here in the meeting, and just make sure nobody's taunting you during this process. We're going to reconvene here. Senator Kirkpatrick.
Thank you, Mr. Chairman. We're working on some language that if the prosecution and the defense agree, that the judge would then have discretion to do something different with the sentence, but I'm waiting on the language.
Okay.
So,
Okay, go
Mr.
ahead.
Chairman, I do think there's an opportunity to change the language, but I don't think we're going to have language ready in time to vote on in this committee. And so I'm happy to continue working on it as it moves through the process and crosses over to the House.
Sounds good. Thank you very much. So now we have a perfecting committee substitute that is up to the committee's will. Motion to pass from Senator Williams. Do I have a second? Second from Senator Dugan. Any further discussion? Seeing none, all those in favor, please raise your hand. 1, 2, 3, 4. Opposed? 2. 4 to 2. That passes. Best wishes in the Rules Committee. Next bill we're going to hear today is Senate Bill 78, which is Senator Robertson, our Vice Chairman. Oh, sorry.
Now, are you comfortable, Mr. Chairman, presenting from here?
Please, you can stay right
Okay.
there because they can still see you at home.
Okay. For the millions of Georgians watching.
They are.
SB 78 is, again, something that we always talk about, a very simple piece of legislation. This bill provides, as you see, for ATVs that are using to damage individuals' property from fleeing from law enforcement, attempting to elude police officers. It gives officers the opportunity that once the individual is apprehended or the vehicle is taken, that such property would be subject to civil forfeiture in accordance with Chapter 16 of Title IX, provided, however, that the civil forfeiture proceedings would occur after the case had been adjudicated, unless otherwise agreed to by the owner or the interest holder of such vehicle through whatever means that may be obtained. And then it has the requirements where the law enforcement officer involved would have to store the vehicle. And understand, this is would not only impact those vehicles that we see screaming up and down the paved roads of our community. I think a lot of us were sent a video today from a four-wheeler on the streets of Savannah that caused a fight at a intersection. But this is also for those individuals in rural Georgia, like Harris County, where I am from tearing up private property of owners and along the power lines, which contain a lot of our critical infrastructure, such as utilities and things of that nature.
Thank you, Senator. I think this is a very straightforward bill. Are there any questions from committee members? Senator Jackson, how did I know?
Thank you, Mr. Chairman. Senator Robertson, can you talk to me about lines 26 and 27 when it talks about moving it to the nearest garage or safe place of safety? Whose garage are they moving it to?
Any law enforcement officer shall be authorized to move or cause to be removed to the nearest garage or other place of safety any off-road vehicle that has been used in land disturbing activity on the property of another when the operator thereof has not been issued a permit for such activity. In other words, the officers are required to secure the vehicle. They can't load it on the back of their truck or whatever and take it home. It has to be put somewhere where it's safe and secure. What most law enforcement agencies do, those that tend to participate in property seizure and the forfeiture proceedings, if it comes to that, they usually have a leased piece of property that they use to store that type of equipment in so that it can be inventoried and maintained.
So it's the nearest garage that is within law enforcement's control or something? Like,
It would have to
it's
be-
not my nearest.
it
It's
would-
not my garage if I happen to be the nearest, right?
No, the Bill of Rights protects law enforcement officers from coming into your house and storing evidence.
But it doesn't specify. That's what I'm
right,
confused by.
right.
So,
Well, if they have a four-wheel, I wouldn't mind if they put it in my garage.
I mean, I'd be fine with that. I'm just
Yeah.
trying to. I didn't understand what
Yeah.
nearest garage meant when it doesn't
Yeah.
say who that garage belongs
It's
to.
within the jurisdiction of the law enforcement agency that's, that handles the case. I can't speak for DPS, but I'm sure they have facilities that they use. I know the Muskogee County Sheriff's Office leases warehouse space. I know that Troup County Sheriff's Office has space for seized equipment and vehicles, as do most other law enforcement agencies. And in some of the more rural counties, they do use where they lease basically small storage buildings to put evidence such as this in, because they are responsible for it, to maintain it and take care of it.
Okay, and then just as a follow-up, so the definition of land disturbing that you reference is if anybody's riding an ATV on somebody else's property, by virtue of the vehicle itself and the tires, there is some type of movement of soil that is going to happen. So does this essentially mean if you are riding your ATV on somebody else's property, you will be in violation of this law?
Well, first of all, if you're on someone else's property without the permission, there's an issue there to begin with. But second of all, some private rural areas, such as the expanse of land across from my house, there are trails that individuals do ride these types of vehicles on, but it's very closely controlled by the man who owns all that property. On my particular property, I do not have any trails. So if they got down in the creek in my property and tore up the creek banks, which would cause erosion and damage to my property, then that would be land disturbance. If it's a trail, then there's necessarily not land disturbance associated with the trail. The trail could just be a trespassing charge.
Okay.
All right. We've got two people signed up to speak, but in the essence of time, Neil and Gordon, raise your hand. You're for this bill, correct?
Yes, sir.
Okay. Well, don't talk us out of it then.
Motion do pass.
I've got all right, motion to pass from Senator Williams, a second from Senator Goodman. Any further discussion from the committee members? Seeing none, all those in favor, please raise your hand. One,
Largest
two,
landowner
three,
in
four,
South
five. All opposed, please like sign. 5-2, this passes. Best of luck in the Rules Committee.
You and Bill Gates.
And last but certainly not least, we're going to do Senate Bill 217. I'm going to start to present this bill, but I'm going to ask Mr. Sean Cunningham to go to the podium. For those of you who have not met Sean yet, I introduced him in our first meeting. He is our intern for the Public Safety Committee, assisting myself as well as others in our office, such as Senator Robertson, Dolezal, Anna Vitarte, as well as Walker. And I always ask our interns to come up with an issue they're passionate about. And I will compliment Sean, who went far beyond that. And went all the way to the point of helping to draft a bill with Legislative Council. He met with all of the parties that I directed him to get feedback, and is addressing an important issue about ghost plates. And he's going to tell you a little more about them, but this is a problem today. Where many of you have seen a license plate in the car in front of you that either is tinted so much that you can't see it, or if you try to get it on video or a photograph, it'll actually white itself back out. You can't even get a copy of what that looks like. It's actually some pretty amazing technology if they just would have used it for good. But this is to address some of those issues. So I'm going to turn it over to Mr. Cunningham to give us an update on his bill.
Well, I want to thank the chairman and the committee for having me here to speak on this today. Really appreciate the opportunity. To start off with the title, Ghost Plates Act, this is going to be fairly all-encompassing for any way that people are going to be obstructing, defacing their plates, or using false plates in order to hinder law enforcement investigations. It's any way that people are going to be altering their plates of registration in order to not be found while committing crimes. That is what this term will define. To start off, this is to try to help tackle increasing crime, gang crises. I was very well prompted by Senator Jones's bill earlier for talking about street racing and the takeovers that we've seen a lot recently in the city of Atlanta. And then on top of that, as we've been furthering our LPR, our license plate reader technology, a lot of law enforcement these days is starting to become more and more automated. These obstruction of these plates highly inhibits the ability of law enforcement to keep track of speeding violations in school zones, as well as just tracking crimes through our CCTV surveillance throughout the city, which can hinder anything from, like I said, traffic tickets, all the way up to concealing much more serious crimes in which a car is used as a getaway vehicle. This is consistent with what we're hoping with a governor's programs to try to crack down on these said crimes. And in this process, I've met with district attorneys, Police Chief Association, Sheriff Association, the GBI, the Georgia State Patrol, Department of Highway Safety, Department of Revenue, and other police foundations to ensure that this lines up with what they'd like to see. So the general goal of this legislation is going to be better tracking criminal activity and protecting our citizens more on the roadways. Would you want me to walk through the different sections of the bill?
We will do that. If you could, please just rattle through the groups that you met with and got feedback from and who are supporting the bill now.
Yeah, so like I said, so far, district attorneys, specifically Fulton County, I discussed with them a lot. They were on board with the legislation, as well as the Police Chiefs Association, Sheriff Association, Georgia Bureau of Investigation, Georgia State Patrol, Highway Safety, and the Department of Revenue were all contacted, assisted in tracking or creation of this legislation.
Very good. Okay, let's very briefly go through each section. Just, I think Section 2 is fairly straightforward about really outlining what a ghost plate is until you get to line 56 and it starts talking about the penalties, right?
Yes, sir. So in Section 2, it's going to be setting our definitions for concealment and alteration of plates. It's what the language law enforcement is going to be used to penalize for these crimes. And then going into, we're kind of restructuring the criminal charges behind these things. We had 2 or 3 separate Georgia codes under 40-2. We're bringing these all into one encompassed umbrella, laid out set charges for repeat offenses as well as enhancements for if felonies are committed at the same time as these plates are being obstructed. And within this language, we did make sure to work in it's obstruction that's willful, it's intentional. So this isn't you have a dealer plate that's accidentally covering up your registration tag. This is intentional obstruction of your plates. And then going into Section 3 and 4, that's covering how we're repealing these codes to bring them into the same umbrella under 40-2. And then under Section 5, it's revising the old code to bring it up to date, and it moves the language that was in this section under 40-2-6. And then finally, for Section 6, it deals with the suspension and cancellation of registrations. That's going to be covering all of the regulations that law enforcement and courts have to go through in order to make sure that on these repeated offenses, we can go through and properly suspend and revoke registrations if necessary.
Okay, thank you very much. Questions from the committee members for either myself or Mr. Cunningham? I got a question from Senator Goodman.
I was just curious, so, you know, I've farmed all my life and grew up on a farm, and a lot of our farm trucks, you know, we used to haul peanut wagons and stuff like that, and we'd hook them up, and, you know, you're trying to back up and telling somebody to back up, and, you know, they come back too far and the tongue hits the license plate or whatever, you know, or like when I'm spraying and we haul 1,600 gallon nurse tanks and I'm trying to back up and hook up, and I just wonder if there's been any thought towards, you know, agriculture, and if this would affect farmers who are in the middle of trying to get their crop in and they got a dented up license plate because they've been trying to get their crop to the peanut buying point or the cotton gin or whatever.
I think, Senator, if I could help answer that, I think it says when he or she willfully with the intent to obscure or misrepresent, which is found on line 46. So I think in a case of somebody, and I have done that, by the way, backed up and crushed a license plate and tried to crinkle it back out till you got a new one, that is not certainly doing anything with, well, not a peanut wagon. Thank you, though, for that clarification. It's a tough crowd around here. All right, but I believe that is covered.
Okay,
So
thank you.
it was with a trailer. Thank you, though.
Mr. Chairman, is this
Yes.
the first bill?
You know, that's a good question. It is the first interim bill of the session. There's no doubt about that. You can haze all you want. So. Other questions from the committee members on Senate Bill 217? We're looking at LC 393785.
Real quick comment.
Quick comment from Senator Robertson.
On line 68, I just want to tell you, I appreciate the hard work you've done on this legislation. I've witnessed a lot of it, and you've been enthusiastic and driven with this. But I do appreciate the consideration you got to those with financial hardships who may end up that being the only vehicle, giving them the opportunity to save the vehicle by transferring the title if need be. So that's a unique aspect of this legislation that I could see being addressed in future legislation. So I appreciate your hard work on that, Sean.
Sir, I would have to thank Ms. Doherty from the legal team for assisting me in this writing. She gave me a lot of great insight and help in drafting this, and I go ahead and relay that to her as well.
Thank you. So I'm just going to wrap this up. If you think about the work that Senator Emanuel Jones did both last year and this year to talk about all things that are street racing, oftentimes the first thing they want to do is obscure their license plate because they're going to get hit by either a street camera or an individual's camera or whatever it happens to be. And this is another way to tell those that want to commit illegal acts that you're going to be held accountable. And a goal is we want it all go away, and we don't want to ever have to issue these things. But I appreciate the great work. I hope this is a message for anybody who is here listening in the hallway or online, that we've got a young man here who came in to intern while he's in college, and he's literally going to help try to change the law to make it a safer place to live. And kudos to you, Sean, for a job well done. So before Senator Dugan walks out, what's the will of the committee? All right, I got a move to pass from Senator Payne, a second from Senator Goodman. Any discussion from the committee? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. Wait, who's the no? 2 noes, okay. All right, congratulations. Best of luck to us both in rules. Thank you all for attending today. This meeting of the Senate Public Safety Committee is hereby adjourned.